morning, everyone, and thank you for joining us for the Tri-State Prompt Payment Act webinar, Pennsylvania, New Jersey, Delaware, sponsored by ABC and Cohen Seglias, Palace, Greenhall, and Furman. Today, our speakers are Shawn Farrell and Tony Byler, both of whom are partners in the construction group at Cohen Seglias. Shawn handles cases through all phases of construction law, from negotiating and drafting construction contracts to litigating cases. He shares his expertise with numerous clients and trade organizations on topics such as mechanics liens, surety law, approving and pricing construction claims, OSHA violations, and alternative dispute resolution in the construction industry. Tony focuses his practice on representing public and private owners, contractors, subcontractors, and material men. He's handled major construction disputes for both plaintiffs and defendants involving educational facilities, hotels, bridges, high-rise residential buildings, prisons, wastewater treatment plants, parking garages, docks, assisted living facilities, and shopping centers. If you have any questions during the webinar, please type them in the question box on the webinar control panel, and we will answer them as they come. Without further ado, here is Shawn and Tony.
Good morning, everybody. I want to start off by thanking the ABC for putting this together, and in particular John Judge, who did a tremendous job getting his organization, the Southeast chapter of the ABC, together for this kind of seminar. I think
along with the Delaware chapter and the New Jersey chapters.
Right. I think that associations like the ABC are really an integral part of construction today. They provide a great service for their members. What they do is they allow us to get together and exchange ideas that ultimately will help each of us act in a more responsible, professional manner in the construction industry, protect our companies, and make a profit. I want to digress for a second from the actual seminar to tell you kind of how I got into construction law in particular. It started back in the 80s, and I was working for the World Bank at the time. And if anyone doesn't know, the World Bank lends money to other countries. Countries build bridges, roads, infrastructure, and then they eventually, believe it or not, expect those loans to be paid back. And there was a high correlation between the success of any project and whether or not those loans were ultimately paid back by the countries. And during that process, in my involvement with the World Bank, we were tracking why some projects failed and why some projects didn't fail. And what really started to intrigue me and what led me on to this 18-year venture of my career trying to help construction companies is I noticed on failed projects, there were times that, as one would not naturally think, on a failed project, companies failed. They went out of business. And on some of the projects, even though they were failing, the companies did okay. And yet on others where they were failing, they did better than they ever anticipated doing. And from that moment on, I tried to figure this paradigm out. Why were companies doing better on failed projects? And what I've come to the conclusion of, and I think Tony shares this as well, but I'll let him speak to it, is it's project management. It's project management. If the project management of a construction company are asshole with tools at their disposal to make sure that their contracts are being enforced and to make sure that they're being paid timely and to make sure that they are protecting the company that they work for, those companies can sustain even failed projects and still come out okay. And that's one of the tools that we're here to talk to you about today is the Payment Acts. So let me see if I can get this clicker to work. I think everybody who is on, you're going to have a screen, and we're going to work through that screen to make sure that you guys can follow us along, and we can get you a printout of all this information. I don't think that it's been provided to you before today.
At the end of the program, there will be a slide that will show Shawn's and my contact information. So should anybody wish to get a hard copy of the PowerPoint presentation for today, because there's a lot we're going to cover, and there's in some cases much detail that can be of assistance to you, you can email Shawn or I after the presentation. We'll make that clear to you again at the end.
Right. So. And if you have any questions during this seminar, please feel free to email us. This is your seminar. We're here to answer any of your questions. We can, on now you're looking at several different statutes and laws that are available in every state, and we're going to focus obviously on the Prompt Payment Act claims. But if you have a question about this lien or a bond claim or how it ties in, or in litigation and you want to, email us something, question about it without obviously naming any of the parties, that's okay, and we will address all those questions as they come in. So we're not going to wait to the end. So if you have a question, please just let us know. But as we look at this first screen, you can see there are a variety of tools that are available to you. And you have to know, as the project manager, and I don't know if we have project managers on the line or if we have owners, but wherever you are in the chain, you've got to make sure that your team, is aware of these rights and they know how to act accordingly to protect each claim in a payment situation and a payment bond and a trust fund situation. So you've got to know from the outset, does or do any or more of these acts apply to my project? And obviously the purpose here today is to go through, in particular, the Prompt Payment Act claims. And let me tell you one of the reasons why I think it's important, and Tony, you jump in if you think otherwise. It's important that we understand the Prompt Payment Act because there is a trend that I'm starting to see in the industry, and that is courts and boards of claims, they are enforcing the letter of the contract much more strictly, much more narrowly.
Arbitrators as well, as I've seen.
And what that is doing is reducing the overall dollar figure that claims get at court or arbitration or through a jury. And they're giving these provisions strict compliance and the statutes as well. So we want to make sure that we're aware of our rights under the statute so that we can arm ourselves to get the most amount of money from a change order and get that we anticipated at the beginning of the job. So know that because of that trend, in addition, because of that trend, I think more claims are being resolved in mediation, more people are pursuing mediation. And again, from a company level, Tony and I are lawyers. We've been doing this for about 18, 19 years, I think, individually. So what we're talking about here is not litigation. We're not saying know these acts so you can sue. We're saying know these acts because the trends that we're seeing, it's going to, more likely than not, any dispute that you have, resolve at the company level. And if you and your team are aware of your rights, you can more actively, more entitled to. So looking at what are Prompt Payment Act claims, they are, by statute, a claim that your legislature has given you. Why have they done that? They do that because legislatures have started to realize that you're not always at an evening bargaining position. I think there's a trend within construction. When you start on a job, a contractor or subcontractor may have more leverage, certainly than he does when you're hitting substantial completion. Because at that point, the owner may even have occupancy to the building, you have been paid your full contract balance, and with margins we're seeing today, which is, for a project under $1 million, probably the margins are 10%. For projects over $1 million, they're probably 3 to 5%. So on those kind of margins, your profits really rolled up into the end of the job. So as you complete the job and you lose your leverage, the owner or the contractor above you actually gains more leverage. So the legislature realizing that really there are two golden rules, and the first golden rule is kind of to do unto others as you want done to you, and the other golden rule, which is these days I think just as popular, which is he who has a goal makes the rules. And at the end, it seems that he who has a goal tries to recreate those rules. But what you need to know is that today, the legislatures in just about every state for private, we have it up on your screen here, has enacted a Prompt Payment Act. And that allows you on both public jobs to either get timely paid or to seek additional revenues in interest and or penalties. So we have to be cognizant of that. Here today we're going to focus on 3 states, New Jersey through the New Jersey Prompt Payment Law. Delaware has 2 different statutes, the Construction Prompt Pay Act and the Public Works Prompt Pay Act. And Pennsylvania, which has the Contractor and Subcontractor Payment Act for private jobs and the Commonwealth Procurement Code for public jobs. So I'm going to turn it over to Tony.
Shawn, switch back and forth to each other throughout the presentation. So these 5 statutes that we've just looked at, there's many things that they share in common. As you can see, all of them have a time requirement for contractors and subcontractors to pay down the chain and for owners to pay. They all apply to multiple tiers in the construction industry. They all impose some type of unfavorable consequence. The reason that we're going through 3 states is not only because those of you who are listening in to work within these particular states, each of these states, as we saw, has multiple statutes that apply, with the exception of New Jersey. Each statute was enacted. Each of them had a different drafter. Each of them imposed slightly different terms and different consequences. So it's important to appreciate those differences in order to avail yourself of the remedies. So we'll see a number of differences as we go through, and we'll pick up on them. We'll see that timing of payment is different between these statutes. You'll see that some people have to pay within 30 days of receiving payment. Some people have to pay within 15. That varies statute to statute. The remedies vary. Under some statutes, you get attorney's fees if you're successful or you're the substantially prevailing party. Some statutes have no attorney's fees provisions. Some statutes allow you to suspend your work, and others do not. As we examine all 5 of these statutes, we're going to actually march through 9 common questions. The questions we're going to ask are going to help you to better understand whether these statutes apply to you and the type of work that you're performing. First question we're going to ask is, to what contracts does the Act apply? As you're sitting there on any particular project, you might say, does my purchase order fall with the Act? Does the owner's contract to build condominiums fall within the Act? Those sorts of questions. The second question is, to whom does the Act apply? Does it apply to contractors? Does it apply to subs? Does it apply to sub-subs? Does it apply to anybody below that? Third, who can make a claim under the Act? Fourth, to what payment does the Act apply? Does it only apply to periodic payments? Does it also apply to retainage, etc.? Also, we're going to discuss what constitutes an untimely payment to a prime contractor. These are payments by owner to prime. We're also going to explore what constitutes an untimely payment from a contractor to a sub or from a sub to a sub-sub. As we'll find out, the statutes differentiate these, and they are timed differently. We're also going to discuss what is a proper basis to withhold payment. One of the things that we'll be looking at under the statutes is the statute flows up and it flows down. In certain circumstances, we're going to be asking what gives an owner or a superior contractor the right to withhold payment from you. In other circumstances, we'll be asking what gives you the right to withhold payment down the chain. We're also going to address the consequences of untimely payment, and that's really damages. What are the cool damages or the threatening damages if people don't apply and adhere neatly to the statute? And then, of course, how does one make a claim under the Act, a practical issue at the very end? As we go through these statutes, we're also going to address some nuances of each of the acts. Shawn and I will occasionally refer to a case in which the courts have interpreted the statutes. Generally, these are rare. The statutes have not been widely decided upon by the courts, with the exception of the Pennsylvania statutes. But there's almost no decisions in Delaware and only a single decision in New Jersey.
Right. Let me interject here, because one of the things I like to do with these seminars is give some real-world advice from cases that we're handling, and to give some practical guidance to the participants, the listeners of this lecture. So what I want you to do, and what we want you to do, is understand where all these things apply so that you can start writing the right letters, writing the right emails, putting in your daily log the right information. Because at the end of the day, if you walk in at the end of the day, be it to an owner or to a general contractor, and you've got a stack of documents, you've got letters that you sent out, you've got emails that you sent out. By the way, a lot of these statutes, some that we were going to mention today and some that we're not, they're going to ask you to put things in writing. Emails do constitute writings, okay? In fact, recently I had a general contractor, and I was reviewing his contract for one of my subcontractors, and it specifically put in there that emails and faxes would not be considered writings, only letters as they came in. And then it held you to notice provisions that said within 1 week, within 1 week prior to the first occurrence of anything that causes an increase or decrease in price, you have to put them on notice in writing. 1 week prior. So I've had to have a crystal ball, put it in the mail, and get it in 1 week prior to doing anything before I could ask for more money. Obviously, we struck that from the agreement. But my point is, and as we go through this, it's with the purpose of educating the listeners so that they can start documenting. Because again, as I said in the beginning, when companies that survive and thrive even in hard times, in the hard times that we're in, it's that the project management team is cognizant of this information and then does the next step, which is act on the information by documenting. Sorry to interrupt.
No, excellent point. And that's it. And although we're going to discuss some of the nuances of this act, I think at the very beginning I want to make sure that everybody has an understanding of how this act applies. And perhaps one of the best ways to illustrate this is through a sword of Damocles. I'm looking to my left. I know that Shawn is snickering at me off camera.
Tony's a very educated man, uses big words like sword of Damocles.
So here's
I don't know what that means.
Here's the story for those. There was, this is ancient Greece. There was a member of
It's a case that's in our law firm right now.
For a very long time. Damocles was a member of a court. He saw a king day in and day out eating great food, wearing great clothes, being entertained, and he wanted to be like the king. So he pulled the king aside and said, I would love to change roles with you. And the king said, sure. And for a day you shall have that. So Damocles sits on the throne, and he's eating great food, and he's dressed in great clothes, and he's watching the entertainment. About halfway through the day, he looks up, and he sees that the king had suspended a sword directly above his head, held by a single horsehair. Once he realized this, he no longer wanted to be the king, and he didn't want to be in that position, and he quickly begged to be restored to his position in the court, and the king granted him that. And the king made certain that Damocles understood that to have great power comes with great risk. Well, this is the way of looking at these prompt payment statutes, and I want you to never forget this. Perhaps you can't, it's burned indelibly into your brain. But the issue is this: the Payment Acts gives the person who receives money great power, but it also assumes a great risk with very significant consequences as penalties, interest, attorney if appropriate. The other thing to understand about this sword of Damocles, or the sword that you carry with the Prompt Payment Act, is it's a double-edged sword. So it applies both up the chain from you, the above the chain have to adhere to the act, as well as you have to adhere to the act down the chain. Otherwise, you will also expose potential consequences. So to jump into the act, you will see this is the first question, and the first turns to what do the acts apply. The first statute is the New Jersey Prompt Payment Law. And again, this applies to both public and private construction. It's very convenient in that respect. The New Jersey Payment Statute is only 2 sections long, so it's an abbreviated statute. But it applies to public and private. Entered into after 2006, we know that law has already come into condition. So if you're providing work on services or on projects in New Jersey, this law will apply now. Improvement is broadly and includes almost anything that you can conceive of. It concerns building, repairing, demolishing structures, excavating, dry roadways, furnishing construction-related materials. So the likelihood that this act applies to your contract in New Jersey is extremely high. Very few exceptions.
I can't even, because it's both public and private. So for people that do work in New Jersey, know that this is a tool that you have available to. Same question. Now we're going to move to the Delaware private statute. For those of you who might be noticing, in the right lower hand corner of each of these slides is a state. Hopefully that will help focus what state we're talking about as we go through. This is the private. The Private Act applies to all construction contracts, of course, the exception of certain things. Public works contracts. We're going to accept out the public works contracts. There's a separate statute for that. There's also accepted from the contract the 6 or fewer residential units of construction simultaneously. So if you're involved in a project that's building 6 towns simultaneously, the statute does not apply. If it's 7 townhomes, it applies. It also doesn't apply to alteration or any single residential unit. Okay? So if you're working on a project like that, it does not apply. If you're repairing
multiple townhomes at the same time, then it does apply. And then it also doesn't apply for contracts for the purchase of materials for a person performing work on his own property. The example is you go down to the Home Depot and you order supplies for a project that you're working on your project. Home Depot does not have a Payment Act remedy against you because this is your own project. Oh, poison. This is the Delaware statute. It applies to public works contracts. And a public works contract really means the construction, the alteration, repair, any sort of thing that you can think of, paid for in whole or in part with public funds. So what does that mean? That means if there is a state agency, a federal agency in Delaware, a city agency, a district, a school district, these are public works contracts. And public funds means the funding of those various agencies. So if you're working on a project that is funded wholly by a public agency or in part by a public agency, it could be a public-private partnership, this statute, the public statute, will apply.
Okay, turning to Pennsylvania, and that's our little state right there in the right-hand corner for those who didn't do so well in geography. What does CASPA apply to? And this book commonly refers to the Contractor and Subcontractor Payment Act. We've likened it as CASPA. So what's it apply to? Similar to the Delaware statute, really, it applies very broadly, and there's very limited exceptions. And the exceptions sort of mirror those in Delaware. You see that a lot between these states, New Jersey, Pennsylvania, and Delaware. They really do mirror each other. New York is a little bit different in all aspects of lien law and Prompt Pay Act issues. But these three states really do mirror each other. So again, 6 or fewer residential units, contract for purchase or material by a person performing work on his or her own property. These would be the exclusions. 9 times out of 10, CASPA is going to apply to your project should it be a private project. If it's not a private project and it's a public project, it's going to fall under the Pennsylvania Commonwealth Procurement Code. Now, the difference between the, I actually had an arbitrator, and it was Steve Arbitier, actually, who's no longer with us. He used to be over Byler, but he did a lot of arbitration. And he applied CASPA to a public school job, finding that based upon the definition of the procurement code, it didn't apply to cities of the first class who weren't in the first class, and it wasn't related to the other first class. Now, why is that important? There's a distinction between the two statutes. And we'll talk as we go through the slides a little bit more in detail about it. But the interest rates are different between these two statutes. And what I find most compelling is you to get attorneys is different under CASPA and the procurement code. And while Tony will talk a little bit more about that in the presentation, under CASPA, you have to be the substantially prevailing party. Under the procurement code, you have to prove bad faith. It's a much harder standard to get those attorney's fees. And why is that important? Again, because as a team, when we're looking at this from the beginning of the project to the end, and we're putting people on notice of our rights and whether or not we're seeking interest or attorney's fees, we have to be cognizant of the fact that if we go all the way to trial, the cost, consider it another piece of overhead, that cost could cost you money. And we have a question.
I ask a question. If someone is supplying material to a GC that is doing work on a resident in New York, do we have any claims?
You're supplying material to a GC. I'm going to assume from the question that you're supplying it to to the GC's yard. The GC is taking it up to somewhere in New York. If that's the situation, because that's what it sounds like. Let's say you're providing steel, or you're providing, if you're doing small tools like screwdrivers, rivets, nails, no, this wouldn't apply to that. But if you did steel,
Actually, not New Jersey, not
New Jersey, not New York. Okay, so I don't think my answer is going to, but Tony, we'll see if we agree. If I provided material to the GC and I asked the GC where the material was going to go, and the GC told me it was going to go to a particular project, okay, and that project was bond, then if my invoice reflected that I was providing the material even to the GC's yard, but it was for use on this bonded project, then you would have the rights that would be available in New Jersey under that project. Conversely, though, a defense to that would be, regardless of what he told you, if he could show that that material did make it to that project, then you, in effect, material to a G in Pennsylvania. I think that's where it started. So you would, if you couldn't identify what project it went to, you've sold material just to a GC in Pennsylvania, and Pennsylvania statute would apply.
Yeah, and if it's not, if I understand the question correctly, you know where the material is used. Is that correct?
No, it was for a project in New Jersey, I thought.
Oh, so it is ultimately used in a
Supplying
project.
material to a GC that is doing work on a resident unit in New Jersey.
Yes,
Right.
yes. The statute is going to apply, and what would apply
If
is
you
going
knew
to be,
that the material was going to really get there.
if the material makes its way to a project located in New Jersey Payment Act statute is going to apply, even though the supplies may have been sourced from Pennsylvania or from some other source. The thing with these Payment Act statutes is you ultimately look to the state to which the labor materials are directed, and absent some language in the contract we have time to discuss, to the contrary, the state law that's going to apply is the state in which the project is situated. So in that particular case, yes, it's going to be covered.
But the nuance of the question, and I want to stress this because I have a few cases that concern variation, is if I want the material to the GC in Pennsylvania, how do I know that it made it to a project in New Jersey? Certainly if you deliver the material to the project, New Jersey law would apply instead of Pennsylvania. So again, what I would suggest is if the GC is telling you what project it is, identify that. That should be identified in also that the GC is writing to you a purchase order. The purchase order should identify the project, and the invoices should identify the project. Then the burden will shift back to the GC to eventually, as a defense, if it didn't like New Jersey law, say, I know I told them. It would actually be sort of admitting to a fraud, but he would have to say, even though I told you it was going to go to a project in Jersey, it didn't. So you can get that chain of custody.
Okay. Did you cover this?
I did.
Okay. Then we go to question number 2. And the question number 2 is to whom do these statutes apply? And in this particular case, to whom does the New Jersey prompt payment apply? And it makes clear it applies to private owners, it applies to prime contractors, it applies to subcontractors, which are defined as those people who have a contract directly with the prime. And it applies to subcontractors or suppliers, defined as those people who have a contract with subcontractors. So in this scenario under New Jersey law, and common throughout all of the statutes we take a look at, the statutes apply to 2 subcontractor tiers below prime. We call them subcontractor for first tier and subcontractor for second tier. If you find yourself as a third tier subcontractor or supplier, these statutes most likely do not apply to you.
I think that. So let's talk about Delaware. Delaware is very similar to what Tony just said. The opening that Delaware provides you, however, is that the statute's kind of written ambiguously in the definitional section of what a contractor is and a subcontractor. So in Delaware, while it's certainly to a contractor and a subcontractor, I think a good argument can be made that it would also apply to a third-tier subcontractor. Would you agree with
Correct, that? I agree. It's not carefully written. I think there's no case law that's been developed, and the statute isn't clear, but it should apply. Going to CASPA, did we actually skipped over, I think?
Well, the public and the private were the same. It applies both in Delaware. The definitional sections mirror each other both in the public and the private statute. So I think that you can make an argument that a third-tier subcontractor, be it on a public job or a private job, this act would apply to that level.
Then we go to CAP, which is the Private Pennsylvania Act. Again, it applies to owners, contractors, and subcontractors. The interesting thing about the statute is the statute defines contractors as designers, engineers, and professional service providers. In fact, professional service can be read broadly to cover accountants, attorneys, etc., which is interesting. It also applies to subcontractors and to sub-subcontractors. So Pennsylvania law goes to second-tier subcontractors as well. It does not extend below that. The law is it's defined very neatly. To whom does it apply under the public Pennsylvania statute? The answer is it applies to 4 entities: to the governmental agencies themselves, to design professionals. It does not apply to attorneys or accountants under the public statute. It applies to contractors and subcontractors. Government agencies, it would include state agencies, county agencies, municipal agencies. It expressly excludes PennDOT for reasons that aren't clear to me, but there is an express exclusion of PennDOT projects. This public act does not apply to. But it applies to state-aided institutions as well, like Temple University, Penn State, Millersville University, University of Pittsburgh.
So let's talk about New Jersey and who that act would apply to. It really applies to contractors, subcontractors, and sub-subcontractors. And that's an important distinction. In I think 2007,
these are entities who could make claims.
Who can make claims under the act. And that's important in New Jersey. In 2007, that's when they last amended the New Jersey Prompt Pay Act, broadening the scope. Now, I want to make note that Jersey, if you were a sub-subcontractor and you were on a job with a bond, you had free notice to the general contractor for existence before you would have any bond rights. Okay? What's significant, and one of the things that I think that motivated the legislature to broaden the statute, was there is no pre-notice requirement in New Jersey relating to the New Jersey Prompt Pay Act. There is with bond law in New Jersey. There is not. Well, there's also a pre-notice in New Jersey. So at the beginning of the presentation, I mentioned that the Prompt Pay Act would just be one tool in your arsenal to seek payment for the work that you performed. But I want you to be aware that the legislature has broadened the New Jersey Prompt Pay Act to go down to sub-subcontractors to protect those people getting payments. And you should also know that if you're doing work in New Jersey, your sub-subcontractors don't have to give you pre-notice. You may, if you're the general contractor, you may never know of the sub-subcontractor until you get a letter saying that you're violating the act.
Correct. Under Delaware, the private statute, claimants include contractors, architects, engineers, real estate brokers. We've shown them on this slide, subcontractors and suppliers. It's very broad. And under the Public Act, we have the same broad application. Under this statute, suppliers and subcontractors aren't defined, but we know that, again, it applies to at least first and second tier subcontractors, and an argument can be made that a third tier subcontractor or supplier would also have the right to prosecute claims.
So in Pennsylvania, who can make a claim under CASPA? It's everyone we just talked about being the contractor and the subcontractor. What's a claim? Let's start very succinctly. What is a claim? A claim is a request for money, time, or both money and time. If you do not have a signed change order, you have a claim. Pending change orders are not change orders, they're claims. A construction directive, a CCD, is an agreement that it's outside your scope, but it's not an agreement to price. So now you're limiting your claim to what is going to be the cost of the work. Under all of those situations, then, where you do not have a signed change order, you have a claim, the act applies, and you should be putting them on notice that not only are you owed money, but you're owed interest, penalties, and potentially attorney's fees if you can't resolve what the monetary amount is going to be. So similarly with the Pennsylvania Procurement Code, it applies to prime contractors and subcontractors, architects, engineers, and surveyors, and it applies to any claim, a claim again being a definition of we do not have agreement. Not that they don't know that you're seeking it, but we don't have agreement on the price, the time, or both.
Right. Then we're going to the next question, which is to what payments do these statutes apply? And we're looking at New Jersey. New Jersey statute indicates that it applies to all billings. What does a billing mean? It suggests that you look to the contract itself to determine what it is that that you can seek payment for. One caveat that I would say to what Shawn mentioned earlier, and this is a carve-out with respect to the New Jersey law. New Jersey, unlike the other statutes, says that only written approved change orders actually fall within a payment that is subject to the statute. The other statutes are silent to that issue. But it includes periodic payments, final payments, the written approved change orders, and release of retainage.
Similarly, Delaware has a similar statute and scope to what payments does the Act apply to. Progress payments, final payment, approved change orders, they all apply, and retainage. And that's a big push. So how do we use this knowledge? If we're sitting on a project where it's completed and retainage is outstanding, we know it's very difficult to get retainage. That's always a fight. Again, writing letters, letting them know that you're running interest on that retainage under this Act is a powerful tool to motivate a owner to close out the project. Tony?
Then we go to CASPA, and CASPA applies broadly again to all payments that are identified under the construction contract. CASPA is actually it's a great statute, and the Pennsylvania Code, the public code, does the same thing. It does this. What it does is it suggests that you take your contract and you insert the terms of your contract into the statute, such that if a party is not paying you in accordance with your contract, that is by itself a violation of the statute. So oftentimes when you're dealing in Pennsylvania, whether it's private or public, look to your contract and be guided by the type of payments that are identified in your contract. And if it indicates that you are to be paid an amount or a type of payment by a particular period of time, those terms are incorporated into the statute. Again, as we look at the Public Act, it's exactly what I just said. Again, it incorporates the terms of your contract into the statute. Parties are required to pay strictly in accordance with those contractual requirements. And like CASPA, it applies broadly to final payment, periodic payment, change orders, and retainage. So new question number 5. Is
that me? Oh. So what constitutes untimely payment to a prime contractor under the New Jersey Prompt Payment Act? This means that you have the obligation to be paid 20 days after the owner receives your invoice, unless he provides you within that 20-day period of written notice as to why he's not going to make the payment to you. And that is a very significant and powerful tool that you should be aware of, because if he doesn't say within 20 days why he's not paying you, it's deemed that he owes it to you. Very powerful tool, and that should be in your letters, your writings, and your oral communications with the owner.
Actually, before we go off this slide, you'll see that there's a case that we cited at the bottom of the slide. This is the only known published case in New Jersey. In fact, it was a decision by the trial court called Air Enterprises versus County of Warren. And in this particular case, the court looked and had to decide whether a contractor who had provided in part shoddy work was entitled for payment to the work that it performed, because the owner, in this particular case a municipal entity, failed to provide that written notice of a defect within the 20 days that the payment was to be made. And the court found that even though the work was in part defective, the contractor was entitled to Payment Act damages simply because the owner failed to provide notice. So it's of prime importance. We're using this as an example in New Jersey, but this is going to be a recurrent theme on all these statutes. It's extremely important that if someone is withholding money from you, that they do so in writing, and it's extremely important that if you're withholding payment from your subs or suppliers, you indicate in writing the reasons for it and do it quickly. And you'll see these statutes have a very compressed period of time to do so. Failing to do that, even if you were deemed to have had a reason to withhold subsequently, if you didn't provide notice, you could still be forced to pay these consequences.
Right. And again, when you're going down the chain, I mean, if you're dealing directly with the owner, I would say put the writing in a letter format. It gets more attention. But to a subcontractor down the chain, if you're going to tell him why you're not going to pay him, you could be in an email. Just retain the email, keep it close by. Yes, question?
Can an owner withhold payment of all dollars of a particular period if only the only issue is one trade sub?
No, and that goes to what has to be in the body of this writing to withhold payment. When they notify you why they are not paying you, they have to pay the difference of the money. So if you're owed $100,000 and they say, well, you did some defective work, and that defective work is about $20,000, so therefore I'm not going to pay you the $20,000, they still owe you the $80,000. And that dovetails into the particular question, which is if another trade contractor is causing some portion of the money of the general contractor not to be paid, the other monies are owed. And it depends on what kind of billing you're doing. If you're doing an AIA billing where you have a schedule of values, it's even easier to demonstrate that you're being paid, your line item was paid 100% of the invoiced amount in any given month, and therefore you should be paid that. Now, while we're on New Jersey, because New Jersey also applies to private work, okay, you can never be the bank for the state, by the way. And this, again, goes to why even if another trade subcontractor is causing the general contractor harm because his work is defective and he's not being paid in full, he owes you the money. He can't get 80% of any invoice in any month and not immediately pay the subcontractors without not only violating the New Jersey Prompt Pay Act, but in New Jersey, the Trust Fund Act as well. So yet another tool for you, the Trust Fund Act, but it's something to keep in mind. Also, when we're talking about public work, because again, this one act in New Jersey also applies to public work, and we said that they have to notify you within 20 days of whether or not they've been paid. Often public bodies do not and cannot really act that quickly. They have to go to a board meeting to approve payments, and the New Jersey Act recognizes that and gives an exception that may extend the time period by which the owner is going to make payment to the general contractor, and thus the time period that the general contractor has to the subcontractor. So if you're on a public job in New Jersey, be cognizant of those payment terms. If you're not the general contractor and you're a subcontractor, ask for their contract. If they won't give you the contract, some people are hesitant to do that. They should at least give you the sections of the contract that concern payment. So just to recap here, what the New Jersey Prompt Pay Act provides, you have to look at the billing date. If the owner has approved and certified your billings, payments due in 30 days after that billing date, unless it's a public entity and it gives itself 45 days, which is typical, or a little bit longer because it has to go to a board. And then if you fail to get notice within 20 days of that billing date, payment is due 30 days after that date, okay? So we've interjected our own panel question just to prompt people, but you guys are being good to ask us questions. If the owner, here's our question, I'll ask Tony. If owner does provide written notice of a withholding, when is payment due for the portion of the billing not withheld and the withheld portion? I think we've answered this. But
Yeah, I think we have answered it.
Yeah. So if anybody has any further questions on that, let me know. But obviously, it's the same time period. You have the obligation to pay the subcontractor within the same time period, the undisputed amounts.
Correct. Right. Then we go to Delaware private work. If we look at the statute, with respect to periodic and final payments, the statute makes clear that an owner must pay in strict accordance with the terms of the contract. So 99% of the time, if you're performing private work in Delaware, look to your contract. Your contract will tell you when you are entitled to get paid, and anything outside of that will be untimely under the Act. Now, if the contract doesn't identify, the statute makes clear that you're entitled to get paid within the latter of 30 days after you submit your invoice, or 30 days at the end of the billing period. Now, in many instances, and again, we're talking about 1% of the time, that's going to be approximately the same period of time. Let's say on a project you submit a payment application on the 20th of February. It's coming up for the month of February. And let's say that the billing cycle is monthly. Well, if you submit your invoice on the 20th of February, you'd be entitled to it 30 days later into the month of March. And if the billing period were defined by the month, then you'd be entitled to it by the end of the following month, which is late March. Here, there's a couple days difference, not a big deal. The problem is if you entered into a contract where payment, the billing cycle is actually quarterly. You'll be able to get paid quarterly. Then, if you submit your invoice earlier, you're going to be waiting until the end of the quarter before you're entitled to payment. Again, this applies really to 1% of the time. It's not a big deal, but the statute does account for that. The statute makes clear that unless the contract says otherwise, what does that mean? It means it can be modified. A contractor may not submit an invoice for final payment until the agreed-upon work is fully completed. Now, what does that mean? The statute doesn't define that, but I think arguably fully completed means you've completed your punch list work, you've submitted all closeout documentation, and then you could submit for your final invoice. But again, 99% of the time, your contract's going to tell you the terms by which you can submit your final payment. Now let's go to Delaware public work, and there, with respect to periodic payments, agencies again are going to be constrained. They have to approve or disapprove a contractor payment submission within 7 days of the date of that submission. So they have a very quick period of time for them to evaluate and approve it. Now, if the agency approves it, then it's going to be certified for payment. The statute doesn't say whether approval constitutes certification. It doesn't say how much time can pass between approval and certification, but it says if the agency approves it, it will be certified. And then, as we see, payment shall be paid before 21 days after that work was certified and approved. So, assuming that certification and approval happens roughly at the same period of time, you're looking at 7 days plus 21, 28 days from the time that you submit your payment, you're going to be paid. However, if there's any period of time between the certification or the approval and certification, that could be extended. If a federal agency is involved, we understand under Delaware law, it also embraces federal funding. The agency has 10 days for approval, so the federal agency has slightly longer to approve than a state agency. Under Delaware public, if we're looking at final payments, agencies are required to issue a payment no later than 60 days after the contractor's final payment submission. With respect to retainage, the statute makes clear that payment is to be paid to the contractor within 60 days after completion or the filing of a notice of completion, or within 30 days if required of the federal agency's final approval or certification. So again, the nice thing about the Delaware statute is it's formulaic. You can look to it. You can plug these dates. Once I make my submission, I'm going to be paid within a certain period of time. If that does not happen, the agency is in violation. I do want to note that the agency is given permission to retain payments longer than 60 days on final payment. But if it does so, it has to notify you of the specific reason in written notice within 10 days of its receipt of your application, identifying reasons that justify the delay. And read as a whole in the statute, they would have to provide a good faith basis for that withholding, and the withholding would have to be made in a reasonable value. If the withholding does not bear reasonable relation to the value of any work that they're claiming has to be withheld or the cause of that, then the agency would be in violation.
So a lot of these statutes obviously have different days as to when a payment is untimely. What I suggest is you get a copy of this presentation, you keep it in a desk drawer, and when you're on a Delaware job, you open up to the Delaware section, and a New Jersey job, open up to that, and Pennsylvania, open up to the Pennsylvania section, because it's all a little bit different. And what you should be doing from today onward is on the very next day from when these deadlines are due, you should be discussing, I didn't say sending, but you should be discussing with your project team whether or not you're going to put somebody on notice of your rights under this act. I say discussing because obviously CASPA, which is the slide that we're on now, says even interim partial payments are due 20 days after the billing period. Does that mean on the 21st day I'm writing somebody a letter asking for the money? No, because that person is going to give you a never-ending punch list if you're going to be acting in such a manner.
That's true.
But again, if we understand the spectrum of a job and our leverage, as we get to the end of the job, we start to lose leverage. And that's when we have to be more diligent with letters going out, with the notice that they're violating the act. So one of the things that you can proactively do is have these discussions on the 21st day. Hey, do we want to send a letter out? Do I want to send an email out? An email, even though it's a writing under the law, it is still an informal manner of communication. People don't take emails with the significance that I think that they should in today under our current law. But should I be sending an invoice out and then following with an email on the 21st day? You should be discussing that. With respect to retainage, obviously CASPA says within 30 days after final acceptance of the work. So what should you be doing as you're coming down this bell curve towards the end of the job? You should be indicating in emails and later in letters what the end of the project is. Are they going to accept a certificate of acceptance of all the work? The owner might not do that, especially on a public job, for months after all the work is completed. But especially as a subcontractor, you want to be identifying to the general contractor, my work is done, I'm done, I'm 100% complete. You should release my retainage currently. So that's one of the things that you can proactively do. In Pennsylvania, under the public procurement code, you have a little bit longer. It's a 45-day period. Again, we should be discussing with our project management team on the 46th day, what are we going to do, and are we going to put somebody on notice? I went too far. With respect to final payment on a public job, is when the work is substantially complete. What does that mean? What does it mean for you? Again, the squeaky wheel gets greased. If you're saying, I'm substantially complete, you're violating the procurement code, I'm going to now start charging interest. You can use that interest as a loss leader. You can use that interest as a negotiating point to get timely payment. And what should they be doing? They should be reducing your retainage. Are we writing the right letters? And knowing that the Act provides you with some protection there. And of note, we have substantial completion occurs when the project can be used and occurred for its intended purposes and must be at least 90% complete. Are we writing the letters that say that? Because again, if that's the issue of the litigation, we should coin that language, because that's pulled right from the statute. That should be in our emails. Hey, just letting you know, substantial completion occurred. You can use the building for its intended purpose. And we are 97% complete, and therefore we should be receiving final payment, or you should just be withholding the amount of money to do the punch list work.
And if that doesn't get the response, then it's an identification of the statute at issue and,
right,
and a listing of the potential consequences.
Exactly, exactly. So let's keep in mind on how we're going to use this information. Once the deadlines are missed, are we going to write the letters, and what are the letters going to say? You can aid in this whole process of getting final payment. I think it's most useful on the final payment as opposed to the interim payments.
Right.
If you know that you can affect when substantial completion is going to be deemed by a court to have been completed. Because keep in mind, if it ever goes completely south and it falls in the hands of Tony or I, the decision of when you reach substantial completion won't be decided by the general contractor or the owner. It's going to be decided potentially by a jury of 8 people, the judge at a bench trial, or an arbitrator.
Right. We've gone on to the next question, and that is what constitutes untimely payment to a subcontractor? Shawn and I have been talking about what constitutes untimely payment to a contractor. If you're a sub on a project or a sub-sub or a supplier to a sub, these timeframes are going to apply to you. Under the New Jersey prompt payment statute, it says essentially look to the contract, and you have to pay within the terms that you've agreed to. If the contract is silent, then payment must be made to you within 10 days of the receipt of your customer's receipt of payment on your behalf. So if the contract says you get paid within 30 days of the contractor's receipt of payment on your behalf, then that's the law. And if it's silent, you get paid in 10 days. The note that we have here is in case of ongoing work on the same project for which partial payments are made, payment is due only if the work is being performed to the prime contractor or the subcontractor's satisfaction. What does that mean? That's what the statute says. The statute doesn't define what constitutes satisfaction. The unfortunate thing is we've all encountered, I think, contractors that we work for who's that rolling stone contractor, who can't get no satisfaction regardless of what it is that you perform. And I think the statute, even though there's no case law on this, the statute is likely to be interpreted to say, look, if the work would be reasonably performed under any circumstances, and the person who's withholding money from you doesn't have a reasonable basis to do so, or is withholding without good faith, the fact that it claims to be dissatisfied is insufficient. On Delaware private, we moved to Delaware. Delaware private statutes. I don't know if many of you know this. I don't know that many attorneys know this, quite frankly, but under Delaware law, in private contracts, a contractor is required by statute to include in its contract a payment clause obligating it to pay the subcontractor and suppliers within 30 days, requiring its subs and suppliers to pay within 30 days after the amounts are received. If that clause exists and the contractor adheres to that, the contractor, of course, has 30 days to pay the subs from the time that it receives payment from the owner. If no timing clause exists, let's say that the contractor doesn't adhere to the statutory requirement to include this clause in its contract, the statute actually ups the ante. It requires that the contractor pay its subs within 15 days of its receipt of payment. That's actually a tool that can be very nicely exploited if you happen to be a sub and the contractor is dragging its feet on paying. Under the Delaware Public Works Statute, if we look at periodic and final payments, contractors and subcontractors have to pay down the chain within 21 days of its receipt of progress payments and final payments. That's fairly clear. And with respect to retainage, it too is within 21 days. So there's a nice parallel between those payments, those types of payments.
Right. And again, we said that this would be similar, Delaware, Pennsylvania, New Jersey, and it is. So if we look at CASPA, it's just a different timing requirement, but CASPA says that you're going to pay a subcontractor or subcontractor 14 days after the contractor and or sub gets the payment. Very similar to the Delaware statute that Tony just spoke about. It requires, before the contract is executed, that the due date for the payments be identified to the subcontractors and puts in a timing of 20 days after they get it. If it's not in the contract, is the way you're going to get it. So the point of this is you should know by contract when you're going to receive the payment, and if you're not, the statute is obligating the contractor to pay you in a certain time period. So refer back to this. Know that it also refers to retainage, 14 days after receipt of payment. So if at the end of the job, again, we're looking to close out the job, we're looking to get a retainage. That might be where most of our profit is on the job. At this stage, I think the project management team, when it sits down on the 15th day to discuss why they haven't received payment, really you should be sending out a letter, and you should be referring to this statute to motivate them to comply with CASPA. Very similar CASPA, again, on private jobs. On the public jobs in Pennsylvania, you have the same requirements that payments are going to be tendered within 14 days after receipt from the owner or from a subcontractor. Again, it is a tool by which you can use to settle disputes before they get to the mediation stage, before they get to an arbitration or litigation stage, by identifying these statutes and letting them know that you know your rights on these jobs.
Before we go on, Shawn, since we're on this slide, it's important to know this. We've talked about obligations that contractors have and that subcontractors have. One of the obligations that contractors and subs have is that before they enter into a contract down the chain, they are required to place the contractor below them or the sub below them on notice of the timing of its receipt of payment from the owner. So a general has to include in its contract in Pennsylvania, under Pennsylvania work, I will receive payment on the 15th day after making my application to the owner. If it fails to notify the contractor below it of the payment terms coming from the owner, then what happens is the statute will infer that the contractor was actually paid in accordance by the owner on that date, whether it was or not, and it can make a payment demand upon the general for the payment, and this applies down the chain. here's the point, and this is a powerful tool for you, and it can be a detriment. Make certain in your contracts that you are identifying down the chain when you are to receive payment from the entity above you in the contract chain. Failing to do that, your sub or your supplier might avail itself of this statutory tool that we've identified here and say, you failed to identify when you were to be paid, therefore you are deemed to have received payment in accordance with that contract. Pay me whether you've received the money or not. This is a great end around of pay if pay and pay when pay clauses that I've used for a number of contractors. I know that you have too, Shawn.
Yeah. So I think this flips over to you.
We actually have a question.
Okay.
Do you have any rights on both public and private jobs when the GC does not submit timely applications for payment, i.e. skips a month and submits application for payment to owner for 2 months at a time?
Well, that's a problem. The tool that I just described is a way around that issue.
I think it addresses that issue.
It addresses that very issue. The thing is, you have to be lucky in that particular case that the contractor above you didn't provide you with notice as to how the owner was to be paid. Now, if you're outside of Pennsylvania, and let's say that this is a contract that involves Delaware or New Jersey, and you don't have the ability of the Pennsylvania statutes to help you in that case, I think you've got a real problem, because what you would have to do is you'd have to look to your contract. If your contract says that you are entitled to payment based on the receipt of the contractor above you's receipt of payment, then its dilatory actions are only going to delay the receipt of its payments. I think you're stuck. I think you have a problem. Now, it could be that you could start to say that you have equitable claims for the work that you performed against the owner, and you could look to different remedies. But I think you would have a problem. Outside of Pennsylvania, you have a problem. Now, the question is practically how do you address that? And I think what you do is you say to the contractor who isn't submitting on a timely basis, you have to submit on a timely basis. If you don't, we're going to go to the owner about this, because the owner certainly isn't going to want to have us file lien claims to the extent that you have lien claims, isn't going to want to know that its subs are not being paid in a timely basis. I think that's the way that you work.
Yeah, I'd ask for a joint check, since you're probably in that situation.
If it isn't just a one miss, if this is a constant miss by the dilatory action.
So let me ask you a question. Pennsylvania, just to bring this point home, in Pennsylvania, if I am a general contractor and I do not put in my contracts going down to the subs when I'm going to be paid, and the owner has not paid me, and in my contract, though, it has paid if paid in it, you believe this statute then allows you to say, regardless of the paid if paid, because I didn't know when the payment terms were, you have to pay me?
Yes. And I've used that as a tool, and I've convinced many in the context. I haven't had to litigate that issue, but I've convinced many in the context of arbitration and mediation.
See, to me, I would disagree with it. I would disagree. I think it's a brilliant tool, and that's why, again, these are tools to be used. And no doubt you've been able to convince others to pay you. But I don't read the I think paid if paid would be enforceable, and that would speak to the payment terms. I would argue that does speak to the payment terms, and therefore that's got to be enforced. And I don't know of a case on point, to be honest. Do you know of a case directly on point?
No, there's no case on that issue.
There's no case on that issue. So, depending on where you are on this issue, to our listeners, depending on where you are on this issue and where you are in the chain, you can use that type of argument to foster payment if you're a subcontractor, and if you're a general contractor. What I would argue is that the payment terms are provided. They say you get paid when I get paid, and I haven't been paid, and therefore I'm not going to pay you. So it's an interesting issue, one of first impression in Pennsylvania, and I don't know that it's ever been dealt with in any other state either.
But the statutes don't allow that in any other states. That's the unique quality of the two statutes in Pennsylvania. What I will say is one of the services that the firm provides is we provide form contracts for our various contractors, and we provide for prime contractors contracts that they pass down to their subcontractors that are very favorable to the prime contractor. One of the things that we do in the forms that we roll out to our clients is we identify, there's a section that we set aside, identifying the specific payment terms from the owner to the contractor to make certain that our general contractor or prime contractor clients are complying with that aspect of Pennsylvania law.
Right. Well, see, again, this brings home the point that I said in the beginning, that associations like the ABC are very valuable because it brings people together, and you can share information, exchange ideas to get new information, because you can bet I will now be taking Tony's idea and running with it for any contractor who finds himself in that situation. So continuing on.
So we're now going to the seventh question. We're getting towards the end. The seventh question is, what is a proper basis to withhold payment under these statutes? And in particular, what is a proper basis for the owner to withhold from a contractor, and what is a contractor and subcontractor's basis to withhold down the chain? By the way, I'm distracted by the image in the top right-hand corner. It looks like it could be pickpocketing. Usually when there's a sign that tries to prohibit something, there's a slash across it, so I don't know if it's encouraging pickpocketing or lewd acts. I'm not certain. Do we have a question?
We do. What if you are a material supplier using a credit application with 30-day terms?
I don't know if I understand the question.
Okay, I guess the question is, you're a material supplier. You have your contractor or the purchase order identifies 30-day term. So you provide supplies within 30. Or you provide the supplies. You invoice. You're entitled to payment in full within 30 days of the invoice. That's the contract that you have with your customer. Assuming that you, the suppliers, falls within a second tier, then the supplier is going to have a contract claim if the payment isn't made within 30 days, and should also have a Payment Act statute claim. I don't see any differentiation between a supplier or any other contractor. We know under the Pennsylvania statutes, the 30 days is going to be read into the statute, so that is the time frame that the customer has to pay the supplier. So yes, the failure to pay within 30 days is going to be a violation of this. Not only it's going to be a breach of the contract, it's also going to constitute a violation of the statute. All right. So as to what is a proper basis to withhold, under New Jersey, the answer is not defined, and there is no case law. So I offered as a panel question to Shawn, what is a proper basis?
There is no proper basis. I represent too many subcontractors.
That is more often than not the answer that we provide. The statute is silent. The statute speaks in one aspect about good faith, and it says that if a party does withhold money, it says that a contractor can't suspend work if the withholder is acting in good faith to try to resolve that dispute. I would argue, if this issue came up, and I'm certain we will be arguing this at some point in time in front of the courts, that if somebody does withhold money, it's going to have to be on a good faith basis. And if we reflect to the sister states, we'll show that their statutes require a reasonable relation between the amount withheld and the reason for it. Justification.
Let me, all kidding aside, in New Jersey, I mean, it really depends on the context that we're talking about, whether or not it's private or public work, because this act applies to both and the basis to withhold.
Right.
And I think Tony is right. It goes to the good faith of whether or not there's a legitimate dispute and whether or not you're paying the undisputed amounts. That, I would say, is probably pretty square on a private job. On a public job, the problems that I see more often than not is the general contractor is submitting in its invoices. It's trying to maximize the amount of money that it gets paid, and then it gets the money from the state, and then it realizes it has a problem with a subcontractor, and it wants to hold back the money from the subcontractor. And in that context, is that ever proper? And I think it is not ever proper to do that. And I think that, again, I don't want to go into the Trust Fund Act, but I think that additional act that's outside our scope of our seminar here today would tell you that, would tell you that you can never be the bank of the state. And so your general contractor, if you're a subcontractor, can never be the bank of the state. And what it should do is it should write to the agency and say, I don't want the money, I want to send it back. In which case the agency will fall off its chair, it won't know what to do with it, and it won't accept the money back, to be honest with you. It'll tell you to keep it, and then those funds should be put into an escrow account or some separate account. And that never happens either. The general contractor always puts it into its general ledger and spends it. So there's all host of issues, but I don't think, depending on where you are in Jersey, whether or not it's private or public, and that's why I said in jest, there's never a reason, because if you, on a public side, if you get the money, I don't think there ever is a reason. So Continuing on, what about Delaware? Again, I think the legislatures of all these states are of a similar mindset. They're saying in Delaware, if you notify the party in writing within 7 days of receipt of the disputed amounts, that's a proper reason to withhold money. Now, let me note, you should be paying the undisputed amounts, and or you should be being paid the undisputed amounts. And if you're not, then they are violating the act. How about on the public sector within Delaware? The agency has a little bit more time. The agency can issue a writing within 21 days, and it should detail why they're not paying you. But again, even the agency, once we get through the disputed amounts, it should be paying you the undisputed amounts. And it may withhold 150% of the amount of the expenses the agency reasonably expects to incur in correcting the deficiencies identified. This is a problem because in Delaware, when you have certain agencies, that leaves a lot of subjectivity as to what is the 150% of the amount of expenses. What is that, and what expenses are they including in there? So if in Delaware you're under this situation where they're withholding money because they believe that there are expenses that they are going to incur, as part of the project management team, you've got to be testing why they're holding back money. Box them into a corner. Why are we holding back money? If they're holding back money because of potential LD issues, all right, fine. Let's know that in month 1 so that by month 3, when we get a recovery schedule out there that shows that we're completing on time, we can go back to the agency and go, well, you specifically said you were holding back 150% of my payment application because there might be 5 days of delay on the end of this job. I just got your revised schedule, and guess what? We're no longer being delayed. We're going to complete on time. So it's important as a useful tool for the project management team that we send out emails or letters, and we're documenting in meeting minutes or in our daily logs the reason that the agency provided to you. Go ahead, Tony.
Now, the comment that I would add is, and we know this from personal experience, you know this from personal experience, that when you're dealing with public agencies aren't always very sophisticated in the way in which they approach construction projects. Many of these public agencies, they could be school boards, they could be local entities, have never put out a sizable project, and they're not as sophisticated as their private counterparts in knowing what is proper to withhold, what amount to withhold. So I think you have to be very careful of this provision that allows the entity to withhold up to 150% of what they suggest is proper. And as Shawn goes to the next slide, in particular, we'll see that what you have to do is not only contest the amounts that are withheld and the basis for the withholding, but demonstrate, use these catchphrases that are in the statute, indicate that you believe that the entity doesn't have reasonable grounds for withholding that, and indicate that there's no reasonable relationship between the value that they've set aside and the value that they claim to have, and that it's without good faith.
Absolutely. Those are good points. So another thing that you can do from today forward is to be cognizant of that, and I would say do the same thing also in New Jersey and Pennsylvania for any job when they're withholding money. Test the reasons. Eventually, should you get a worst-case scenario where you find yourself embroiled in litigation, the reasonableness of the withholding is going to be tested, and the person that comes off bad, juries will punish. So if I was even in Pennsylvania or in New Jersey and I was being told we're withholding money because of potential LDs, I'll stick with that analogy. And then a recovery schedule came out that showed that you were on time now, and they still withheld the same money. Well, that really will cast them in a bad light. That will aid you in all other, prosecution of your claims. So
that's exactly right. Going now to CASPA, the Private Pennsylvania Act. Here, owners, contractors, and subcontractors all may withhold values according to the terms of the contract. Again, Pennsylvania makes this very neat. Your abilities to withhold payments are tied to what you've given yourself, what you've negotiated in your contract. But they can do that only if they satisfy 2 additional steps. First, they have to notify the party whose payment is withheld of the deficiency item within 7 days of the date that the invoice is received. So again, there's a very compressed period of time that your customer up the chain has to identify for you why it's going to withhold payment. If they fail to do that, it's going to be deemed an approval of that payment. The same way, if your customer is submitting an invoice to you you have a duty to act within 7 days, unless your contract terms are different, to identify what is properly withheld. And failing to do that, you run afoul of the statute. And again, as Shawn's been saying, and as the statute makes clear, you have an obligation to pay the value of the work satisfactorily completed. A deficiency item under the statute is defined as work that's not certified by the owner, the contractor, or anyone above you as conforming with the plans and specs. It's kind of straightforward. If there's a problem, it's usually because it doesn't conform with the specs. It could be that you don't have enough people in the field. That's another basis, but in particular, you have a 7-day period of time to identify the basis of withholding. Now, here's something else that the Pennsylvania private statute does. This is actually pretty cool. I pat the legislators on the back for this. They recognize that there's a difference between withholding money for deficient work and failing to process a payment application because of some perceived deficiency in the application itself, a documentary error. So the statute has been made to speed up the process of payment. And it says if anyone receives a payment application that is deficient, it doesn't tie out a line item. It shows a percentage of completion greater than actually was performed. Not a deficiency in the work performed, but a documentary deficiency. Then the entity, whoever that is, has to provide written notice, not just notice. You can't call on the phone. The statute makes clear it has to be written notice to the other party within 10 days of that documentary problem. Failing to do that, they've essentially waived their right to contest the way in which the application was submitted. This actually played into, I was able to exploit this section of the statute in a case where I represented a construction manager who was working for an owner who was a deadbeat. And unfortunately, the construction manager had a contract that said, I will incur costs. As I incur costs through the subcontractors below me, I will pay them and then seek reimbursement to the owner. And what happened is the construction manager actually didn't pay. It just took the invoices and passed the invoices along to the owner. Well, ultimately, there was a dispute. And the owner tried to say at the last minute, you have no Payment Act damages. You have no rights. Your claim isn't right because the construction manager never actually paid the subcontractors. And what I was able to do, convincingly, in the context of that mediation, to get the outcome that I wanted, is I refer to this section of the statute. I said, show me a piece of paper in which you complained that our invoices were submitted incorrectly. You didn't do it. You didn't do it. It's waived. You have to pay us for the value of the work that was performed. Going to the procurement code, the public statute in Pennsylvania. The statute in Pennsylvania, or the public side, differentiates between a proper basis to withhold from a governmental agency and contractors and subcontractors. So first, with respect to a governmental agency, it can withhold, again, according to the contract, but it has to notify the basis of withholding within 15 calendar days of the application, and it has to pay for the satisfactory work. In connection with a contractor or subcontractor on a public project, they can, again, withhold the value of the deficiency items. They have to notify, and here's something very important again. They have to notify not only the subcontractor within 15 days, the contractor or the subcontractor is required to notify the governmental agency of that withholding within 15 days too. How often is that done? Never. It's never done. So again, when it comes to exploiting this, I've represented subcontractors where the contractor said, no, I put your contractor on written notice of the deficiency within 15 days. I say, show me your letter to the owner. I don't see the owner carbon copied on that letter. Again, it places me in a position of power to demonstrate that they didn't adhere to the niceties of the law. Therefore, they didn't put us on proper notice. Therefore, we're entitled to payment as the work was performed. Again, there's an obligation for all of us to play nice in Pennsylvania on a public project. You have to pay the value of the work that's satisfactorily completed.
Turning to New Jersey, I think the legislature in New Jersey did a wonderful job in amending the New Jersey Prompt Pay Act in about 2007 to really strengthen the ability of a subcontractor or a general contractor to get payment from the owner. Not only are you entitled to the amount you're due under the contract, but you get interest at a prime rate of 3.25% plus 1% for the duration of the late payment. In today's market, that's actually not bad interest rates.
It's making money.
In addition,
I hope that they withhold.
Yeah, exactly. If you can withstand it, it would be great, right? Barring that this should not be used as an investment vehicle, how would I use this? You can use this as a practical standpoint to negotiate quicker payment. If you say to an owner, or if you're a subcontractor to the general contractor, I know I'm entitled to my money. I know I'm entitled to this interest rate. If you pay me within 5 days, I'm going to waive the interest. And if you don't, I'm going to seek the interest. That's a very powerful tool. Also, if it gets to the point at the end of the job and it gets to a litigious avenue, in a civil action, not only are you entitled to such remedies under the Act, but you're also entitled to your attorney's fees to the prevailing party, which is a phenomenal way to describe when attorney's fees are due. Many statutes say to the substantially prevailing party. And then, because we're lawyers and an extra word has been added to a sentence, we'll battle over what's substantial. Is substantial 51%? Well, that's not very substantial. What's the amount of that 1%? Is it $100,000? Is it $200,000? When does substantial get? Is it 60% of your claim? What if you're defending a $1 million claim and you don't have a counterclaim and you defend it? Are you the substantially prevailing party, or did you just prevail because you don't owe anybody money? And courts will oftentimes use that opening to not award attorney's fees. The American rule, unfortunately, is that attorney's fees are borne by the client, and they should not, absent a statute or contract to the contrary, they shouldn't be awarded. And courts don't like to award attorney's fees. I think the line is really drawn into whether or not, again, going back to a theme that we've been kind of running through a lot of these issues, whether or not there is a good faith reason for the withholding and a good faith reason for not paying somebody. To the extent, even if you're going to lose the battle and eventually owe money to a subcontractor, or if the owner is eventually going to lose the battle and owe money to a general contractor, to the extent that there is a good faith basis for the withholding of the money, you're going to at least be able to defend against attorney's fees. But here in New Jersey, that's a different issue.
Yeah, and I'll just note, as we mentioned before, there's really no case law developed in New Jersey on these issues, but in Pennsylvania, the issue as to whether a party is substantially prevailed or not is the #1 reason for published opinions, and the courts are all over the place.
Right.
51% can be a 51% edge at the end of the day can be a
Right.
substantial prevailing party. In other cases, party had to prevail by 75%, and these are the uncertainties of the way in which the statutes are defined. This one is good.
This is because it takes out of the subjectivity of the courts to not award you your attorney's fees. Also, as we identified earlier, there are trends in the construction industry where cases are being settled in mediation or cases are going to arbitration. I think a majority of the contracts still provide, absent it being a public contract, where they still avail themselves of the court systems. In private sectors, more and more disputes are being arbitrated. What does that mean? That means that we have less and less opinions on what is or is not the fact that would award attorney's fees under. So we're really missing the case law, which is the driving precedent for lawyers to be able to say, well, based on these facts, you're definitely going to be able to get your attorney's fees, because in this case, which was much less egregious, the court awarded attorney's fees. The more that we go to arbitration, and I think that is just a unfortunate consequence of arbitration, arbitrations don't have written opinions. Even where they do have written opinions, they're not published. There's no way to find them. The written opinions would just go to the parties. There's no way to research them. So there's less and less case law developing what is a substantially prevailing party. Here in New Jersey took that away, and I think it's a phenomenal tool, and the legislature did a good thing for contractors. Also unique to New Jersey, it says that if you're not being paid under certain circumstances, you can stop doing the work without fear that the owner or the general contractor is going to hire another contractor and hold you liable for the delta or any increased cost of performance. I think that is a phenomenal tool.
There's no other statute that allows that.
Be careful with it. It does not apply under these circumstances. It doesn't apply if you're being paid as required by the Act. If you're getting the payments, you can't walk off the job without fear that you're going to be held liable for the increase in costs. It is not provided a written statement of the amount withheld and the reason for the withholding. What that means is, if I, as a general contractor, tell you, the subcontractor, within the time frame, 20 days, of receiving your invoice why I'm not paying you, then you can't walk off without the potential that you, if wrong, and I'm not, correct in why I'm withholding payment, you can't walk off the job without me holding you liable for any increased cost or performance. And the last circumstance what it would imply is when the payer is not engaged in a good faith effort to resolve the reason for withholding. So it is not as powerful of a tool. It is not, if I'm not paid in New Jersey, I can stop working. These 3 points need to not be present. If they're engaging you in a dialogue, and you as a general contractor to your sub should absolutely be identifying why you're not paying and engaging them in a dispute resolution dialogue so that they can't walk off the job. So it's sort of a dual-edged sword there, but it's a phenomenal tool that you can use in New Jersey. Again, you're not paying me. The Act provides I can walk off the job. I intend to walk off the job. Again, dovetailing in, you haven't paid me, you haven't given me a written statement, and you're not engaging me in a good faith effort. If your letters are saying that and you're not getting a response back, you can walk off the job, in my opinion. If you are the general contractor and the subcontractor is writing you in that manner, you are writing them immediately back. You are telling them, I am engaging you in a good faith basis to resolve this, and here are the reasons that we already articulated as to why I'm not paying you. Even if you haven't put it in writing, now is your opportunity to cure that ill. Put it in writing.
And as a practical issue, I'll just say that I've had success with just the mere threat that the contractor is going to walk from the project. That I have yet to have the threat of a contractor walking not resolved in some resolution, or at least plan for resolution of going forward. So it's an important tool to use and to threaten, rattle that saber, rattle that sword of Damocles. Whether you use it or not, hopefully you won't have to wait to the end of the project to prosecute that.
Will you define what sort of Damocles is at the end of the presentation?
Again, for anybody who wants to follow with the second accounting of the sort of Damocles, they can give me a call.
We'll Google it.
Google it, exactly. Okay. Google provides a very nice definition. All right, is this me or is this still you?
I think this is you. Cap, the next slide. I just did this slide.
Great. Okay. Excellent. So now we're on the consequence, again, essentially the damages for failing to timely pay under the Delaware Private Act. The Delaware statute identifies essentially 3 categories of types of damages, one of which is interest. We talked about how nice the 3.75% was under the New Jersey statute. The Delaware private statute's great. It actually ratchets that up. It allows for 5% over the Federal Reserve rate, the discount rate, which is presently 0.75%. So if you have to pursue interest, or if you have to threaten to seek interest, it's actually 5.75%. That's actually great. And it continues. That interest will continue until the eventual wrongfully withheld payment is made. The statute also provides for additional damage awards for amounts wrongfully withheld. And as the statute makes clear, if arbitration or litigation is commenced to recover the payments and it's demonstrated the party failed to timely pay, the court shall award the amount that's wrongfully paid. Note, an amount is not deemed under the statute to have been wrongfully withheld to the extent it bears, and here's the criteria again, a reasonable relationship to the value of any amount in dispute, or a claim held in good faith. So again, we see those 2 standards coming out. The third damage that the Delaware private statute allows for is attorney's fees and costs. Powerful tool, again, to rattle the saber. The statute's a little wishy-washy, though. It says absent an agreement to the contrary. So your customer can actually write out of the contract your ability to recover attorney's fees and costs, as can you in your contracts down the chain. However, absent that description, an arbitrator in any arbitration proceeding shall award the substantially prevailing party. Here we see a different term. They've added that term substantially. Substantially prevailing party, it's reasonable attorney's fees. Arguably, a substantially prevailing party can satisfy less and still obtain attorney's fees than the party who's required to prevail. The Delaware law is actually on the side of an entity who is seeking recompense for having amounts wrongfully withheld. But attorney's fees and costs is a great remedy. It's one that I think sinks in. When I write a letter, or when my client writes a letter saying, not only do we get all these great things from me, but my attorney gets to send his kids to law school on this, it sinks in. I think that motivates people. They don't like attorneys, and they don't like thinking attorneys sending more kids to law schools. All right. The Delaware Public Statute. It essentially provides two types of categories. The public statute doesn't have a provision for fees or costs. I guess that makes sense. They're protective of the Delaware agencies. They don't want public money, public fists going out the door to pay attorneys to prosecute claims. But it does allow for interest, not as high as in the private context of Delaware. It's about almost as high, 2% plus prime. So it gets it to about 5.25%. Just slightly less than the 5.75% allowed in the private context. And again, it allows for damages for amounts wrongfully withheld. You just simply have to demonstrate that the amounts didn't bear a reasonable relationship or were withheld without a good faith basis.
Turning to Pennsylvania and the consequences of untimely payment, Pennsylvania has certainly given the contractors and subcontractors a hefty interest component, 1% per month. That's 12% per year.
The highest of all.
Yeah, that is a very nice tool to use in a payment dispute that you want to forego having that incurred on you. So again, not to talk out of both sides of my mouth, but if you are seeking payment from the owner, obviously something that you want to put in any correspondence up the chain to the owner that you're tracking this cost and that you want this cost, and then you can use it again as a negotiation tool to get timely payment, waiving that cost if you want, or you're entitled to it, so you might want to hold on to it. If you hold on to it, obviously that probably would chill any amicable resolution, but depending on the amounts in controversy, that might be something we're talking about. But you got to be cognizant that it also runs down to your subcontractors. So again, you got to put them on notice as to why you're not paying them. I would put in your contracts going down the chain paid clauses to make sure that interest is not going to be incurred against you. And then an interesting note, in a lot of the contracts that I review, we see provisions in there that say you waive all rights under the Contractor and Subcontractor Payment Act. Is that enforceable? It is not enforceable. The case that we've cited here for you says, in those circumstances where your contract says you waive all your rights under the Contractor and Subcontractor Payment Act, really all you're doing is you're waiving interest.
And that's only if you're a contractor.
Right. And the reason for that is interest is a negotiable term, and the court felt that it had to give some meaning to the statement that you're waiving your rights under the Act, but recognizing that you can't contract around what the legislature has provided by a statute. Otherwise, we'd have contracts for drugs and other illicit activities, and the courts don't want that.
So the takeaway is in Pennsylvania, even if you sign on your contracts up the chain that you're waiving your prompt payment rights under CASPA, the only thing that you're waiving, arguably, if you're a contractor, is your right to the interest. You're not waiving the penalties, which we'll talk about in a second, and your right to attorney's fees.
Right.
And as a subcontractor, if you're a subcontractor, you can never waive any of those rights.
Yeah. So here's an exciting thing, too, that Pennsylvania's done, and Tony just alluded to it. On top of the interest, you can also get a penalty at 1% per month. So that is another 12% a year, or added collectively, cumulatively, at 24% a year on the amount that they're wrongfully withholding. That is a huge incentive for a general contractor or an owner to resolve the dispute. And if you know about this provision of the Act and you're seeking it, it really can be a motivating factor to sit somebody at the table. I don't know who wouldn't sit down and try to resolve this if they're faced with a 24% interest on all the money that's owed. And that's per month. So it's not compounded monthly. It's 12% annually or 24% annually, not compound interest. That would be really powerful tool if it was compound interest. I think contractors would start rooting not to be paid if it was compound interest.
They come up with ways to kind of find it.
Right. And then the last significant thing that the Pennsylvania legislature has provided on the CASPA, should you find yourself in litigation, is that the substantially prevailing party is entitled to its attorney's fees and expenses. and that is a very significant tool. And I know that you have a case there that you wanted to talk about.
No, the case is just, it goes to show that the courts have been granted an enormous amount of discretion in determining whether a party has substantially prevailed. Appellate courts don't like to be asked whether the trial courts made the right call as to whether a party substantially prevailed or not. So again, it's an issue that should suggest to any litigant who's forced to bring a claim that you can't necessarily bank on getting attorney's fees at the end of the day. It's a great saber-rattling device early on. And it's a great way to get somebody to take you seriously and pay you the balance. But you can't necessarily bank on getting attorney's fees at the end of the day, because what the judge is going to decide is what's going to end up in the case.
And it also might be adjusted by what you eventually win. If you file like 10 claims and you win on 7 of 10, there probably will be some discount in the attorney's fees, because the other 3 that you lost on, the court kind of views, well, maybe you should never have brought them. What you want to be able to establish is that they were so intertwined that it really didn't incur any more additional time adding the additional 3 claims. Or you want to be able to distinctly separate those costs at the time of trial. Should I bring in one more witness for the other 3 issues, I would try to argue that my time at trial just related to that one witness is the only thing that should be discounted. Otherwise, I should prevail on my entire attorney's fees cost. So it's something to think about and something to discuss with who's ever representing you should you find yourself at that point. Turning to public work, what does public work provide?
In Pennsylvania.
In Pennsylvania. And it provides a interest. You can get interest. The short-term interest rate is 2.5% annually, beginning on the 15th day after the payment was due. Again, I find interest is a very useful tool to negotiate quicker payment. I would always calculate it and run it. Show them that you're running it. I would be willing to normally negotiate with interest to a lesser amount or to waive it should we get timely payment and avoid litigation. If you're in the litigation, however, I would stick to it. You also are entitled to a penalty under Pennsylvania law on a public job, and that's 1% per month. That's withheld in bad faith. So here's where I think there's a fine distinction, or a significant distinction, between the public and the private statutes in Pennsylvania, and is with penalties and attorney's fees. Because attorney's fees, which is the next slide, also you're entitled to them, again, if you prove bad faith. Bad faith has been defined as vexatious or wanton acts.
Or arbitrary.
What that means, who knows? There is no better definition of what it means. It is a higher standard than the substantially prevailing party. Basically, it is that feeling you get in your gut when you're dealing with someone. You go, this person is bad, and I don't like this person. They did things not in good faith. They had no justification withholding money, and yet they did it anyway. And under those circumstances, you're going to be able to establish the bad faith that's required. But this is a fact question. It'll be a fact question either for an arbitrator, a jury, or a judge. So it's a little bit more difficult to obtain. It's something that the project management team should be cognizant of, but the extra hurdles that you have to get over to get attorney's fees should also be taken into consideration when you're trying to negotiate an amicable resolution of a job. Tony, you have anything to add on that?
Yeah, on this slide, it's appropriate. So the takeaways under the public statute in Pennsylvania, it's harder to seek an award and get an award of attorney's fees because you have to demonstrate bad faith. That is a higher hurdle. However, some people have been able to hit that hurdle and have convinced courts to award notwithstanding that higher hurdle. And all we've noted is a particular case, A.G. Cohen Construction versus State System of Higher Education. It's a case that came out in 2006 where, and I'm not going to go into the fact of that case, but essentially where the government agency, which was our educational dollars at work, was deemed to have engaged in vexatious conduct by denying a contractor's repeated request to perform work outside of its scope, but necessary work relating to the abatement of lead paint. Again, the agency failed to heed that request on numerous occasions. It had to be performed. It had an impact on a project deemed to have been vexatious. Right. So now we turn to, I believe, the last question of the day, and that is, how does a person make a claim or prosecute a claim under these various statutes? Under New Jersey, and we're going to see a lot of commonality here, under New Jersey it can be done by way of arbitration or litigation. Again, I don't know if you know this, but the statute says that, and by you I mean everybody, the statute in New Jersey says contract shall provide a provision that disputes disputes regarding whether a party has failed to make payments as required by the Act may be submitted to a process of alternative dispute resolution, which is arbitration or mediation. It's a requirement. What's the consequence of it isn't there? I'm not so sure, but the statute imposes that obligation. It does bear out on the remedies that you can get, because I believe that you could get attorney's fees in arbitration, I'm sorry, in litigation, but not in arbitration, as we saw on a previous slide. And that's the reminder. Attorney's fees are awardable only in litigation, not arbitration. So what does that mean? I guess if you're trying to protect
well, I think this is saying that you can go to arbitration and get your attorney's fees.
You can. That's right. That's right. Well, no, it's saying attorney's fees are awardable only in litigation, not in arbitration. That's said. You can bring an action either in arbitration or litigation, but the remedy of attorney's fees is only available in litigation.
I don't agree with that. I've won attorney's fees on the Prompt Payment Act. So.
All right, I'm just going by the language that we of the statute itself. I've attended seminars where people have suggested that a contractor who wants to be cunning should require that it have litigation with its owner or the contractor above it in the contract to try to negotiate litigation terms, and then down the chain make sure that you're imposing arbitration provisions to circumvent that. Again, I think it's an issue of how you interpret the statute, but that's
there's no case law on that point,
there's
and it's open to interpretation. And my practice has been I've been awarded attorney's fees and arbitration. I've certainly heard the argument that you're talking about. It's certainly one that you can make depending on where you stand in the chain, but it is not a foregone conclusion that you can't get attorney's fees and arbitration. As a matter of fact, when you look at the Federal Arbitration Act and the state arbitration acts, both in Delaware, New Jersey, and Pennsylvania, they seek to push all your rights into arbitration and to accept them all. So there would be no logical tie, other than you certainly can argue that that section of the statute may have wording that would lead you to that conclusion. But other than that, there's no logical tie why you would give up your attorney's fees, or why the Act would allow interest and penalties but not attorney's fees at arbitration as opposed to litigation.
Yeah, I think these are the arguments.
Yeah.
Right. Then next, we're going to Delaware, the private act in Delaware. Again, the way to prosecute a claim is both by litigation or arbitration. Again, we've noted here the right of attorney's fees might only be available for arbitration. Again, that's my takeaway from reviewing the statute and reading the precise language that's used. I think the argument can be made both ways, but it's a cautionary note that we make here.
It's a case of first impression for both of these states, and the courts haven't addressed it. So
exactly,
we've got to kind of wait and see on this one.
I guess I'm pushing in through you.
No, you've moved on to you pushed through me.
I'm going to continue to push through.
We'll just keep going back.
Taking Shawn's slide. All right. How does one make a claim under the Delaware Public Act? Again, it's by litigation or arbitration. If we go to CASPA, which is Pennsylvania, the Private Act, again, it's by litigation or arbitration. This is going to be a common theme. There is a provision under the statute that says it's unenforceable to make the contract subject to the laws of another state or require litigation or arbitration or other dispute to take place outside the state. That's a very convenient provision. I've used it before. Unfortunate thing, as I was involved in a case called S&G Electric versus Norman Security, and in there,
one-sided.
Yeah, I'll get the site for anybody who needs it. But in that particular case, I represented an electrical contractor who was in Pennsylvania, who was in Philadelphia, on a Philadelphia project led by the city of Philadelphia. It was a detention center, so everything took place in Pennsylvania. However, the contract between my client and its customer said that any dispute had to be arbitrated in Alabama. So we relied upon this provision of the statute, and we commenced a federal court action, and we said it's entitled to stay here. The statute, the prompt payment statute, allows for it. The federal court, relying upon federal precedent, said, no, this is an arbitration provision. These are parties in interstate commerce, so the Pennsylvania laws don't apply. The federal law applies. The Federal Arbitration Act says let the parties go wherever they want. And in this particular case, we had to arbitrate that matter in Alabama. So be careful what's in your contract, but this is the exception to the rule.
We also had a case where we had the project in Pennsylvania. Okay, all the work was done here. The general contractor was in New York, and the contract said you got to be in New York. And the New York court said, I don't care what the Pennsylvania statute says, you're in New York.
So nice. Again, it's nice to know that the courts actually follow the rules that are laid down by the legislature.
Right.
We have a question?
We do. Is there any time limit to which a dispute has to be addressed in arbitration? For example, if there is a dispute, how far off can the arbitration hearing be set for? Does it differ if it is a public project?
No, I'll start off. No, really, there's no time limitations, and that's the importance of selecting an administrator of the arbitration. Oftentimes you'll see in a contract where it says American Arbitration Association. It will be the administrator of the process. So they are a good administrator. They will. A lot of people don't like the AAA, the American Arbitration Association, because it's a little bit more expensive. And I am one of those people that believe it is a little bit more expensive. And they are still vetting through a lot of procedural issues that they need to get some sort of firm rules on, meaning length of the arbitration. I was once in an arbitration over a $3 million dispute with a school district that took 72 days to litigate. Nothing should take 72 days to litigate. And the cost of arbitration for 72 days is very expensive. So that is not a good thing. So a lot of people don't like the American Arbitration Association. One of the benefits of the American Arbitration Association is they will timely prosecute the claim. So once it goes to arbitration, if it just says we're going to go to arbitration or we're going to agree upon an arbitrator, that can add a substantial amount of delay into the process, because then the parties have to find somebody who they agree will arbitrate the matter. Once you eventually select an arbitrator, there is no timing constraints where the arbitration has to be done at any particular time. Those are provisions that the parties can agree upon, and if your attorney is doing a good job, he should be bringing up those issues and trying to get the other side to agree upon when's the arbitration going to take place, do we need discovery, how long is it going to be, and how many days do we have for the actual arbitration, so you don't find yourself actually in litigation for 72 days. But outside of an agreement in a contract, you're left to your own devices. What most people find is that it's sort of no one wants to push it too long because both sides are splitting the cost of the arbitration. So it's almost mutually assured destruction. You want to get to the end because both clients are paying for the cost. Do you have anything to add?
Yeah, I do. And I interpret the question asked in a couple of different ways. I will say that the statutes, none of the statutes has an express requirement that arbitration be commenced in any period of time. It's just a forum that the statutes allow the parties to pursue. Whether you will end up pursuing an arbitration or litigation is going to be determined by the provision in your contract. If you're given the opportunity to arbitrate, you will arbitrate. If the question goes to whether there's a period of time that you have to commence arbitration so as not to waive your claims, the relevant statutes of limitation are going to govern.
Right, but there is no, so in Pennsylvania it's 4 years, New Jersey it's 6 years, and I think it's 6 years in Delaware as well,
right,
for breach of contract. But there is no, so outside of that, there's no limitation of the remedy which this Act provides.
Right, and then that's right. If it goes to the timing of the completion of arbitration, again, the statute doesn't speak to it. There's really two ways that this is going to be controlled. And I can speak to some degree because I'm actually a member of the I'm an arbitrator on the American Arbitration Panel.
Another reason not to like it.
that Shawn threw under the bus here. But the nice thing about the American Arbitration Association, not to come to its defense, is that it does, in the training sessions that all the arbitrators are required to go to, there's emphasis placed on quickly resolving the dispute. I think most claims that are commenced in arbitration are resolved. I've seen the timeline within 200 days of the date that that the original demand for arbitration is put in place.
And there are, for lesser, I should say this to AAA's defense, for fast-track arbitration, which are disputes, I think, under $50,000.
I think it's
$75,000. An award has to be rendered within 60 days of the arbitrator being selected.
Right.
So
that's correct.
For smaller claims, again, you're going to get one arbitrator. When it gets over $1 million, you get to 3 arbitrators. But smaller claims, you get one arbitrator. And if you agree to fast-track arbitration, you can really streamline the whole process. But again, the point here is it takes agreement.
Yeah. And I think from a procedural aspect, if you put it into the hands of AAA or another arbitrator, it's going to take the time that's necessary. One of the things that you can do to become proactive, to lessen the cost that you're likely to incur, is engage your attorney. Talk to your attorney about the way that your contracts are set up, and have your attorney help you draft appropriate language that will suit your needs. If, for example, you only want to have an arbitration that's completed within 60 days of the filing of the demand, put it in your contract. If you want to restrict the number of arbitrators that are going to be serving, place that in your contract to reduce the cost. If it's to achieve a certain result by a period of time, put it in the contract. Those are enforceable. Those two types of provisions are enforceable, and an arbitrator is constrained to follow those contractual limitations. Yes, another question.
If the arbitration is on contract with the school district for final payment of the last 5% of their retainage, if the GC prevails, can or does the GC get interest and/or subs affected?
Yes, you would. If I understand the question correctly, you're suing for the retainage, correct? That's what it says.
Yeah.
So if you're suing for the retainage, and I'm assuming you're in Pennsylvania and New Jersey and Delaware, actually, because we've run through all three. This
It's between a GC and the agency, not us as a sub.
okay.
This is now 6 months old. The arbitration hearing is set for July. Is that normal or reasonable?
You read that question so fast. Let me take a look at it. If the arbitration is on contract with school district for final payment of at least 5% retainage, if GC prevails, can or does the GC get interest and or the subs affected? The GC is entitled to interest, and depending what your contract says going down the line, the subcontractors would also be entitled to interest because these acts would apply to them, and they could be making claims against you for the interest. And then I think it goes on, this instance is between GC and agency, not as a sub, and dispute is now over 6 months old, and arbitration hearing is set for July. Is that a normal or reasonable time? It depends on how many issues you have over the retainage. Oftentimes, people aren't going to file for litigation until they have a full understanding of what the issues are. That would take substantial completion, finish up the punch list, and you would go. So right now it's February, and you're talking about July. With 5% of retainage on a school project, I just can't imagine what the issues would be that you would need that much discovery time. But again, there might be a lot of issues. It might be related to multiple trades, and therefore the owner and or the GC is seeking additional time to take discovery outside of any disputes between the parties. I mean, you need a third party to give you documents, and that would be a normal time. Most litigation, to put it in context, on a normal track, non-complex piece of litigation that you're going to try before court, you're going to get 8 months discovery. On a complex issue, you're going to get about 13 months discovery. That's in most courts around the country. So putting that in context, 6 months is not that bad. 5% of retainage, that's the only thing. The amount in controversy doesn't seem high enough that you would want that much discovery. And typically in arbitration, if you're following the American arbitration rules, you don't get the ability to take depositions. You can exchange documents, but you don't get the ability to take depositions unless there's an extraordinary circumstance and the arbitrator issues a ruling allowing those depositions. And suppose a third party is even rarer. So I'm not sure why it's taking that long. 6 months is not outrageous, unfortunately, in our world. But given the amount of controversy, and again, I'm speculating on that, I don't know why they need that much time.
Let's just tie this up. This is the public code in Pennsylvania. Litigation and arbitration, again, is the forums for dispute resolution. So now we just have final thoughts on the various statutes. Shawn, I don't know if you want to address the...
Yeah, just a couple of things. I mean, again, tying back our general theme of from today forward, the project management team should be discussing the Prompt Payment Act as a tool to motivate people to stay out of litigation by paying you on a timely basis. I wanted to point out one of the things with respect to the Delaware Act that I think is extremely strong, and that is that it impresses upon the contractor who might receive monies for its subcontractors a trust. And what that means is that there's a fiduciary obligation then, once you have these funds in your hand, that you're going to pay your subcontractors. What that means when we talk about fiduciary obligations is that people with check writing authority have personal liability as to why those funds aren't paid to the subcontractor, and if used for general expenses of the company as opposed to being paid to a subcontractor, could subject them to personal liability. These are, again, very powerful tools. When you know of it and you're putting this kind of language in a letter that says, hey, listen, I know that I'm owed money. I know that you hold the money in trust. I want to know where the money is segregated out of your normal general ledger and where it sits. I don't want to make sure it's protected. I can tell you that no general contractor is doing that, that I know of. So it puts an immense amount of pressure on the general contractor once he realizes that those acts may subject him to personal liability to resolve your issue. Conversely, if you are the general contractor, I would caution you not to use those funds or put those funds into your general ledger. But if you have a good faith dispute with a subcontractor, segregate them out. Tony? I think this was you. Was this not you?
I don't think so, but that's okay. I can talk about it. The final thought in context of the Public Works Prompt Payment Act is that just be aware that the agencies are given, like we addressed some of this before, are given some ability to adjust the terms. I'm not going to go in depth on this point, but there is a section of the statute that says that the agency can change the time frame to pay and the reasons to withhold, but it has to do so by publishing a posting on every single plan and every single contract document, identifying their ability to change those times. It's such an owner's obligation that it is not going to happen that frequently. I think it's something that we can gloss over for the most part, but they can change those times. Final thoughts on Pennsylvania's CASPA. I had argued before that the failure of an owner to disclose, a contractor to disclose to a subcontractor is a way to get around the pay if pay and pay when pay provisions. There's been a couple of cases, a district court case and a common pleas case that says there is no end around. The statute doesn't provide you with a way to get around pay when pay or if pay. But the facts of those cases were not similar to those that I said, and the ones that I was using were cases where the contractor failed to disclose to the sub before entering into a subcontract the terms by which he or she was to be.
The court hasn't addressed that. That's case of first impression. The other case I would say that these are very powerful clauses in your contract, and just so everyone is cognizant of what they mean, paid when paid and paid if paid are very different. Paid when paid says you're going to wait a reasonable period of time before you sue anybody for your contractual remedies. Paid if paid says if the owner doesn't pay the GC has absolutely no obligation to pay the subcontractor. So that all the risk is imposed on the subcontractor that the GC gets paid. So that would be if I hire Tony to go out and build a house for me, and he builds the house for me, and we have an agreement that if I don't get the funding for the house, that I don't owe him anything. Well, guess what? If I don't get funding for the house and he built me a house on my land, not only do I not have to pay Tony, but I get to keep the house. That, in essence, is a paid if paid clause. Not very favorable if you're on the back end of it, but extremely enforceable. So be cognizant of them, negotiate them out of your contracts when you're the subcontractor or a general contractor. Well, general contractor, unless you're tying into a financing, you probably wouldn't see it. But if you're the subcontractor, negotiate them out. For anybody going downstream from you, a sub-sub to you or a sub to you, you want that in your contract so that you have the ability to not have to pay somebody before you get paid.
And believe it or not, it is a huge negotiation victory if you can modify a pay if pay to a pay when pay clause at the end of the day, because it assures that you will eventually get paid. Just an issue of time.
And I'm not saying, I would not advise anybody not to enter into a contract because it's paid if paid, but that's not a love job. That's a job where you're going to build, quote unquote, financial float into your change orders. That's a job where if someone wants to borrow a scissor lift, you just don't give it to them, you rent it to them. If it's paid if paid, you're going to have to be able to know that when I get off this job, the last payment, especially retainage, if it doesn't get paid, I don't get paid. So you've got to really protect yourself. You've got to be very on top of that job.
The last point on CASPA, for if anybody out there is an equipment lessor, we've represented Komatsu dealers, Caterpillar dealers, people like Modern Equipment. Those people, unfortunately, under the present state of the law, are exempted from CASPA. There's a horrible decision called RICO Equipment versus Subric. It's a Superior Court decision. It's waiting for somebody to overrule it. It's a bad decision. Essentially, it said that a contract between a lessor of equipment and a person who uses that equipment is not a construction contract as intended by the legislature. Horrible decision. But beware, if you fall in that category, you do not have, under the current state of the law, remedies under CASPA. Sureties are not liable under CASPA. So if you are trying to prosecute a payment bond claim and you're threatening to hit the surety with prompt payment provisions under the current law, they are not liable. And then third-party claims, and this is a problem. This is the insurance or bonding lobby worked this little piece of legislation into CASPA. It says once a contractor has made payment to a subcontractor, all future claims for payments against the contractor or the contractor sureties are barred. So it actually negates a subcontractor's bond claims, arguably, by act of the statute. Now, I haven't litigated that issue yet. I think it's going to happen at some point in time because it's such a powerful tool in the hands of a bonding company. Third-party claims, again, this is the same comment that I just made a second ago applies to the public statute in Pennsylvania as well. It has the same provision. The same lobby got to the legislature when it came to enacting the public statute. That concludes the formal portion of our presentation. Unless Shawn has any concluding remarks, I'd like to thank everyone for participating. We just went a little bit over our allotted time, but we hope you had an opportunity to hear some issues that you didn't understand or fully embrace before. We hope we've answered some questions you might have. Of course, after this presentation, if any of you have not sent questions, but you have a question that you want to have answered, please communicate with us.
Right.
And if any of you have asked questions, but you want to double-click on those, please feel free to circle back to us. Shawn?
Yeah, I'll just dovetail on that as a sort of as a commitment to the ABC. Tony and I have agreed that if a contractor has a question on these types of issues and they want to give us a telephone call, we don't charge for that kind of telephone call. I know most attorneys, they tell you 3 jokes and you get a bill for $500 and they weren't that funny. We don't believe in practicing that way. We want to get in front of the issue and make sure you're protecting yourself. If eventually something happens in litigation, that's an unfortunate but inevitable consequence, I think, of the industry that we're in. But for small questions about the acts or what applies, do I have a Prompt Pay Act and a Mechanics Lien Avenue? Can I go on both of these fronts and things like that? Feel free to reach out to us. We have no problems giving you a call and answering those things. That's part of our commitment to the ABC. So with that, I think...
if anybody does want a copy of the presentation, just feel free to let us know, and thank you so much for joining.
Thank you.
Thank you.